Friends, I welcome you all to lecture number 3 in Sale of Goods Act 1930 in CA Foundation sponsored by Sri Jendra Rangzone. I am your mentor Shekhar Gehlot. So till now we have discussed few things about what is a good and how the sale of goods take place, what are the kinds of sales we have. In this chapter, in this lecture, we are going to continue further on contract of sale, how it is to be made, what are the conditions, what are the warranties in a sale of good and how important they are. Okay, so let us begin with contract for sale, how made. Okay, so we all know that sale can only take place through a contract. Okay, unless there is a contract there cannot be a sale. Okay, because otherwise the sale would be marred by different conditions which hamper the forming of a contract. Okay, any contract can come into existence only on consensus and either meeting of minds. Okay, for sale of goods meeting of mind must happen in same thing in same sense. If I want to buy wheat, I mean wheat and of that particular grade and of that particular quantity and of that particular price and deliverable by that particular date. That is how a contract of sale is made. According to section 5.1, a contract of sale is made by an offer to buy or sell goods. Okay, what how the contract is made? Contract is made by an offer. There has to be an offer. Okay, what kind of offer can be there? The offer can either come from buyer. If buyer will make an offer, then it will be an offer to buy. If the offer is coming from the seller's perspective, it will be an offer to sell goods for a price. Definitely price has to be there. Any agreement or a contract without consideration is going to be void. Okay, so for a price and the acceptance of such offer. Very simple, just like a contract, just like we read in the contract act. There has to be an offer for a price and then offer must be accepted. The contract may provide for the immediate delivery of goods. Contract may provide for immediate delivery of goods. There may be immediately deliver it. Like I have been telling you, I go to a South Indian restaurant, I order a dosa. Okay, they serve me a dosa, I have it and I pay the price. That's it. Immediately delivery of goods or immediate payment of price or both. Okay, or there may be a immediate payment of price, but delivery may be at later stage. Okay, goods may be delivered immediately with price being paid on a later date, like in EMIs. Okay, goods are delivered immediately to you but you pay the price on a later date. Or price may be paid immediately but goods are delivered late. Okay, when will this happen? Usually it happens in distance transactions. Okay, distance transactions where parties are at a distance with each other, or like in online shopping. Okay, online shopping, you make a payment via your credit or debit card and the goods are delivered on a later date. That is when you are paying the price immediately but your delivery is happening on a later date. Okay, similarly, if you are opting for cash on delivery option, there is an option which says cash on delivery, that we will deliver you and you will pay the cash. Then delivery is made only after payment of cash. In that case, both is happening immediately. It is a case of immediate delivery and immediate price. Okay, immediate price and immediate delivery, they are both happening simultaneously at the same time. Okay, or for the delivery or payment by installments, or there may be EMIs as well. EMI option may also be there. EMI option may also be there, or that the delivery or payment or both shall be postponed. There may only be a contract where delivery and price both shall happen on a later date. Both shall happen on a later date. Okay, it is also very much possible. It is also very much possible. Just like we discussed a cash on delivery option. The contract is complete. When you click OK, I'll pay by cash and the order is booked. The contract is complete, but sale will be made when the sale will be finally made. Sale will be made only when you make the payment in cash when the delivery person is standing at your doorstep. That time later, okay. Postponement on some later date, you will get the delivery as well as you will make the price, but today you are entering into a contract of sale. Very much easily understandable in common parlance as well. Further, as per subsection 2 of section 5, subject to provisions of any law for the time being in force. Okay, subject to provisions of any law for the time being in force, a contract of sale may be made in writing or by word of mouth, or partly in writing and partly by word of mouth, or may be implied from the conduct of parties. Okay, there is, that means, Sale of Goods Act does not provide any particular way in which contract or sale may be made. Okay, it does not mandate anything. It may be in writing, oral, oral plus writing, or by conduct. This is called implied. It may be implied from the conduct of the parties. You may enter into a contract of sale through your conduct as well. A contract of sale may be made in the following modes. A contract of sale is made by an offer to buy or sell goods for a price and acceptance of such offer. Okay. There may be immediate delivery of goods, like we discussed that there may be immediate delivery of goods. Okay. But price is paid later on. There may be immediate payment of price. There may be immediate payment of price. But it may be agreed that the delivery is to be made at some future date, like we discussed in the case of online shopping. Okay, immediate price is paid, but delivery is made at a later date. There may be immediate delivery of goods and an immediate payment of price, just like we discussed in the case of cash sale. You immediately get the good and you immediately make the payment. That is a cash sale in the market. It may be agreed that the delivery or payment or both are to be made in installments. It may be agreed that delivery and payment both are made to be in installments. Delivery may also be made in installment, like A ordered 100 bales of cotton. Okay, it is agreed that he'll receive just 10 bales each week, 10 bales of cotton each week, and he'll make the payment for same. Now, in this case, what is happening? Both delivery and payment is made in installment. 100 bales of cotton was agreed to be delivered, but now it is going to be delivered in installments. Similarly, the payment is also going to be made in installments only. It may be agreed that delivery or payment or both are to be made at some future date, like we discussed in the case of cash on delivery option. In the case of cash on delivery option, both are to be made at some future date. Subject matter of contract of sale. What is going to be the subject matter of contract of sale? The goods which form the subject of contract of sale may be. Now, what kind of, definitely we are, when we are dealing in Sale of Goods Act, that means subject matter of sale are going to be goods only. Okay, we are going to deal in goods. And what is a good? As we have discussed, good is a movable property. Okay, or something which is attached to land, but it has been agreed that at the time of sale it shall be severed from the land, it shall be separated from the land, but it does not include actionable claims or money. Okay, so this is goods. This is the definition of goods. Now, what kind of goods could be a subject of sale? The goods which form the subject of contract of sale may be either now it may be existing good. Okay, good. What is existing good? We have done good which exists, which is present with the seller at the moment of entering into a contract. It may be an existing good, or it may be owned. It may be a good owned, something which is owned by seller is not merely having it, but seller also has the ownership of the good, or possessed by the seller. Possessed means seller only has the possession, seller only has the custody or control of goods, but not the owner. Okay, but not the owner. Or future goods. Goods may be future goods. Now you may be thinking that how a seller can sell the goods when he is not the owner, but he is only having a custody or control of the goods. He is only having custody or control of the goods. The answer is in the agency. Answer of this is in the form of agency. Agency, wherein principal is the owner and agent possesses those goods with authority to sell them. Okay, he has an authority to sell them. A very perfect example of this may be salesman coming home to make sale. Salesmen are not owners goods, they are only agents. Okay, they are holding those goods for someone else. Now they are entitled to make a sale. They are entitled to make a sale, and when they make a sale, when salesmen make a sale, it is all legal and valid in law. It is all legal and valid in law. There may be a contract for sale of goods, the acquisition of which by the seller depends on contingency which may or may not happen. There may be contract of sale of goods. The acquisition means seller will get a hold over those goods. Seller will acquire those goods. It depends upon contingency which may or may happen. That means goods could be contingent as well. And we have very well discussed what is a contingent good, which is based upon happening or non-happening of a certain event. Let's do an example. A contract for sale of certain cloth to be manufactured by a certain mill is a valid contract. Okay, such contracts are called contingent contract. Okay, a contract for sale of certain cloth. Now I say I want a dark blue cloth manufactured by Raymond Mill. So it's a valid contract. Now seller will say, okay, I'll place the order. If the mill is still, if the mill is still manufacturing that color and that grade of cloth which you want, I will provide it to you. So it depends upon happening or non-happening of an event. What is event here? Event is whether the mill is still manufacturing the good I want. If it is doing, if it manufactures, then good will be delivered. That is a contract of sale with relation to a contingent good. Whereby a contract of sale, where by a contract of sale the seller purports to effect a present sale of future goods, the contract operates as an agreement to sell the goods. Okay, whereby the contract of sale the seller purports to effect a present sale of future goods. Now in such a case in which contract of sale is made, it shall be agreement to sell, not a contract of sale. Contract of sale will happen only when the good will exist. Goods perishing before making of contract. Okay, now you can even make a sale for goods which are perishing before making a contract. Okay, that is provided by section 7. It says where there is a contract for sale of specific goods. Okay, specific goods means goods are now identified. Okay, goods are now identified. Goods are not general goods, they are identified specific goods. Where there is a contract for the sale of specific goods, the contract is void. The contract will be void. Okay, if the goods without the knowledge of seller, if the goods now without the knowledge of seller, without the knowledge of seller have at the time when the contract was made, at the time, not after the contract, at the time when the contract was made, perished or become so damaged, the goods perished At the time of making the sale, the goods, without the knowledge of seller, have perished. Perished means got damaged or become so damaged as no longer to answer to their description in contract. As no longer to answer to their description in the contract. Contract describes tomato, fresh tomatoes, but tomatoes are not fresh anymore. They are stale, contaminated. Now they do not answer to the description. Okay, now what is the answer to the, what good will answer to the description of tomatoes in the contract? Only fresh tomatoes, not stale tomatoes. So now they do not answer to the description in the contract. So now what will happen to such a contract? Such a contract will become a void contract. Why will it become a void contract? Because we discussed in the contract law, it is a contract made under mistake of fact. Now it is a fact that onion that these tomatoes have become stale or they have perished or goods have perished, but the same is not within the knowledge of seller. He does not know, and especially it should happen at the time. At the time, okay, at the time of contract, not after the contract. Okay, after the contract, if the contract has already been made, okay, the contract has already been made, then the seller is liable to take care of the goods, and if the goods perish in the seller's wash, the seller is liable to compensate. A agrees to sell B 50 bags of wheat stored in A's godown. Okay. Due to waterlogging, but due to waterlogging, all the goods stored in the godown are destroyed. All the goods stored in godown were destroyed. At the time of agreement, neither parties were aware of the fact. The agreement is void. It is void because of the mistake of fact as well as impossibility of performance. It cannot be performed now. Goods perishing before sale. Okay, now goods perishing before sale, but after agreement to sell. What will happen to the situation when goods have perished before sale is concluded, but after the agreement for sale has been entered? Where there is an agreement to sell specific goods, let us say tomatoes or wheat, and subsequently the goods without any fault on the part of seller. Now this is crucial, without any fault. Without any fault on part of seller or buyer, perish or become so damaged as no longer to answer to their description in the agreement before the risk passes to buyer. Before the risk has passed on to the buyer, okay, the agreement is thereby avoided. Agreement will become a no agreement at all. Agreement is avoided. Okay, you can avoid the agreement, it will be a void agreement again. On account of impossibility. How can this happen? That goods perish without any fault on the part of seller or the buyer. Suppose Okay, now in this case, A contracts B for 100 kg of sugar. B also has taken very well care of its go down. Okay, but what happens? A nearby go down catches fire and fire spreads with the wind. It catches B's go down as well. Now the sugar is gone. Go down is gone. Now the contract is void. Contract has become void because it is impossible to be performed. Now contract has become void because there is no fault of buyer or no fault of seller. No one has a fault here. No one is at fault here. But let's assume there is another thing they say before the risk passes to buyer. But this contract is avoided will become void only if the risk has not passed to the buyer. If the risk has passed to the buyer, the contract will be a concluded contract. Okay, the contract will be a concluded contract. Okay, if the risk has already passed to the buyer will be bound to make the payment to the seller. Now let us assume in this above contract, okay, these 100 kg of sugar was marked and set aside in the go down for B. Okay, and the instructions were passed to the warehouse keeper that whenever B will wish, he can inspect the 100 kg of sugar and even take it whenever he wants. No further authorization is required. And then the godown would have caught fire. In that case, B would have been liable to make the payment because delivery in the goods has been made to the B, and now B is the owner of the property. So if loss is there, B shall suffer that loss. A, who is the seller, will not suffer that loss. So A shall be compensated. A shall be compensated. A buys a truck from B. Okay. And instructs to load it in railway for transportation. To load it in railway for transportation. B loaded it with railway as per instruction. Rail meets an accident and truck is gone, or truck is so damaged that it cannot be called a truck at all. Now in this case, because the risk has passed on to the buyer, the buyer is liable to make the payment. Okay, though the buyer has not yet received the delivery, buyer buyer has not yet received the delivery, neither he has made the payment. But because upon his instruction the truck is loaded into the railway, that means the property in the goods have transferred to buyer. Upon his instructions, the truck is loaded into the railway. Now railway catches fire or railway meets an accident. This is beyond the control of seller or the buyer, but buyer must now pay the price for truck. Buyer must now pay the price for truck. Ascertainment of price, section 9 and 10, how the price is to be determined. Now we are having a contract of sale. We are selling goods. Okay, we are selling and buying goods. Now we sell and buy goods for what? We buy them for price. We do not buy them only for kinds. If we are exchanging goods, that is not a sale, that is merely an exchange. Okay, but if we are talking about sale and purchase of goods, there has to be price involved. So when there is price involved, it will become a sale. So now how do you determine the price of a good? Now you want to buy a good, but how do you determine its price? What is the valuation of that good? How is that determined? Okay, between buyer and seller, what are the factors which determine the price of a particular commodity or goods? Let us now examine. Section 9 and 10 says the price in a contract of sale may be fixed by the contract or may be left to be fixed in manner thereby agreed or may be determined by the course of dealing between the parties. Very open-ended section. It gives a lot of options to the buyer and seller to decide the or determine the price. Now, where the price is not determined in accordance with the foregoing provisions. Where the price is not determined in accordance with the foregoing provision. What is the foregoing provision? This provision. If the price is not determined as per this provision, the buyer shall pay the seller a reasonable price. Okay, the buyer shall pay the seller a reasonable price. Now, what is reasonable price? It is a question of fact. It depends on the circumstances of each particular case. It depends on case to case basis. Then, that in this case, what would be the reasonable price? What would be the reasonable price? Okay, now let us discuss the way the price is fixed. There are three categories in which a price can be fixed. In contract by both parties, both A and B, both parties may decide that this shall be the price. This is the most common way of deciding a price. Okay, or may be left to be fixed in manner thereby agreed, or may be left to be fixed in. They may decide that the price shall be fixed in such a manner. What manner? Like price of market on relevant date. Suppose there is a sale and purchase of sugar which is happening in future. Now they say let us determine the price as per the price existing on the date of sale, that whatever be the price of sugar on the date of actual delivery, actual sale, we shall agree to pay the price. Okay, or may be determined by the course of dealing between parties. Okay, may be determined by what are their dealings. They may determine it later on. Where the price is not determined, it shall be a reasonable price, and reasonable price will always depend upon what is reasonable and what is unreasonable. Is always a question of fact, and that will always and always determine, is will always be based upon the each fact differently. Each case shall be treated differently. Now today, if we determine the reasonable price of the gold, the reasonable price of the gold will be the market price of the gold. Okay. Price means the monetary consideration for sale of goods. Okay, price means the monetary consideration for sale of goods. By virtue of section 9, the price in the contract of sale may be. Section 9 says the price in the contract of sale may be fixed by the contract, like we have just discussed. It may be already fixed in the contract. Sometimes contracts are prefixed. Sometimes a contract may be prefixed contract, in which suppose there is a government tender. Government says we will pay only 1 crore rupees. Whoever is willing to come, he may come. Like when we go to buy flats or plot, it is always determined that we are going to sell at this price. If anyone is willing, he may come. Okay, though flat and plot are not movable property, they are not goods, but I am just citing an example. Agreement to be fixed in a manner provided by the contract, e.g., by a valuer. Okay, there may be a independent valuer. Share CAs, you people are going to be CA tomorrow. What is the main job of a CA? Main job of a CA is valuation. Main job of a CA is valuation. Okay. So CA, like a CA may decide the value, that it should be the value. Okay. Or the government as well, like government used to decide petrol and diesel prices. Okay. Or market forces are forces of demand and supply. Determined by the course of dealings between the party, they may sit and negotiate, and they may determine within the dealings that what shall be the price. It is also very much okay. Agreement to sell at valuation. Okay, now what is agreement to sell at valuation? Where there is an agreement to sell goods on terms that the price is to be fixed by the valuation of a third party, and such third party cannot or does not make such valuation, the agreement thereby is avoided. Okay, now we decide that our agreement to sell is going to be valued by a CEO. Suppose A agrees. Now A agrees to sell to B a Picasso painting. The Picasso painting was bought by A's grandfather 70 years ago. That time definitely it may have valued a different. Now who will decide what is the value of that Picasso painting today? Okay, neither A can state with confirmation nor B can state with confirmation. So what they will do, they will hire a painting expert to decide the value. They will hire a painting expert to decide the value. So now what happens in this case if the painting expert fails? Contract will become void. If the painting expert fails to determine the price, the contract will be void, because consideration is the must part of the contract. Provided that if goods or any part thereof have been delivered to and appropriated by the buyer, he shall pay a reasonable price thereof. Now, in this case, if the painting has already been delivered to B, okay, and he has used it or he has not damaged it, now he shall pay a reasonable price. What will be the reasonable price? Again, it shall be determined as per the facts and circumstances of each case. That's it. Where such third party is prevented from making the valuation. Okay, or where such third parties prevented from making valuation by fault of the seller or buyer, the party not in fault may maintain a suit for damages against the party in default. Now suppose we have hired a painting expert to determine the value of a painting which is 70 years old and by a celebrated artist called Picasso. But the seller does not hand over the painting to the determination to the valuer for determining the price. Now, how can he determine the price of the painting without getting his hands on the painting? Okay, so it is difficult for the painter to determine the value of painting. Now the seller is at fault, or the buyer does not pay the price of the. Now it is agreed that both will pay valuer a fees. Okay, definitely valuer will take a fees for making a valuation. So they decided that both will make half fees each. Suppose he is going to take 2 lakh rupees for determining the value. Now they say we will pay 1 lakh each. Buyer does not pay 1 lakh each, and thereby the valuer does not disclose the price. Now, in this case, the party who is not in fault, in case it may be a seller who is not in fault, or in later case it is a buyer, may maintain a suit for damages against the party in default. Okay, so the contract will not be avoided here. Okay, the party can go to the court and make a suit for damages against the party who is in default, due to which the determination of valuation could not be done. Analysis. Section 10 provides for the determination of price by a third party, like we discussed, where there is an agreement to sell goods on the terms that price has to be fixed by a third party, and he either does not or cannot make such valuation. If he does not or cannot make such valuation, okay, now it is fault of the valuer. The agreement will be void, like we discussed. In case the third party is prevented by the default of either party from
It's
fixing the
2 o'clock.
price, the party at fault will be liable to the damages to the other party who is not at fault. Now, the party at fault shall be liable to the other party who is not at the fault. However, a buyer who has received and appropriated the goods must pay a reasonable price for them in any eventuality. Whatever happens, if whatever happens, whatever be the case, okay, there are three scenarios where valuer does not value it, or seller prevents him, or the buyer prevents him. These are three scenarios, but in either of the scenario, if the buyer has got the property and he has used it, okay, then he must pay a reasonable price for them. In any eventuality, in any of the above situation, he must pay a price. Then he cannot say that now contract becomes void, so now I'm not required to pay anything because it's a void contract. No, he cannot say so and run away from his own liability. Let's take an example. P is having two bikes. Okay, he agrees to sell both of the bikes to S at a price to be fixed by the Q. Suppose Q is a mechanic. He'll now inspect the bikes whether the bike are in good condition or not. Okay, so they determine that price shall be fixed by Q. He gives delivery of one bike immediately. Okay, one bike's delivery has been given immediately. Q refuses to fix the price, but Q says, I will not fix the price. That is one situation in which Q has refused to fix the price. So now the contract has become void in relation to first bike. Okay. As such, P asks S to return the bike already delivered, while S claims for the delivery of second bike too. Now P says you return my first bike. Okay, if you will return my first bike, then only make the delivery of second bike. But as says, no, I will deliver return your second bike only when you will deliver me the second bike. In the given instance, buyer S is the buyer because he has now appropriated the bike, he has used the bike, kept the bike, enjoyed the bike, shall pay reasonable price to P for the bike already taken. As regards to the second bike, the contract can be avoided. Okay, for first bike, now S is liable to pay a reasonable price. But for the second bike, the contract is avoided. Seller cannot be compelled to sell the second bike unnecessarily when the contract becomes void contract. Stipulation as to time. Okay, stipulation as to time. What is the relevance of time in a contract of sale of goods? Stipulation as to time, unless a different intention appears from the terms of contract. Okay, unless it starts with a negative covenant, it says unless a different intention appears, okay, from the contract. Stipulations as to the time of payment are not deemed to be of essence of the contract of sale. Okay, it says unless, it says that unless the contract says that payment must be made in the time, and if payments are not made in the time, the contract shall become void contract. Okay, unless it says so expressly, any delay in making the payment of the for the property shall not affect the contract. Okay, any delay in making payment shall not have an effect on the essence of the contract or the performance of the contract or the validity of the contract. Contract shall be valid if the payment is made on the time or not made on the time, or late made late or made in installments. Either way, the payment can be made, but the contract shall remain a valid contract. But if the contract itself states that payment is the essence of time, and if the payment is not made in the time as scheduled out in the contract shall become void. Then payment shall be an essence of the contract. Whether any other stipulation as to time is of essence of the contract or not depends on the terms of contract. Okay, now it depends. How do you come to know that the time is essence of the contract? You will come to know by reading the clauses of the contract. Let's now analyze this section 11. As regards time for the payment of price. Okay, as regard time for the payment of price, unless a different intention appears in the terms of contract, stipulation as regard this is not deemed to be of essence to contract of sale. Okay, unless it is written down that time is the essence of the contract, we will not assume that time was essence of the contract. Okay, but delivery of goods must be made without delay. Okay, whether or not such a stipulation is of essence of the contract depends upon the terms agreed upon. Okay, now these things, that whether time of the delivery is essence of the contract or not, it will depend upon the terms and conditions of the contract. Though it is a rule that delivery maybe should be made at the time, payment may or may not be made, but even delivery may be made at a later date, it won't affect the contract or the validity of the contract unless it is so written in the contract. Price for the goods may be fixed by the contract or may be agreed to be fixed later on a specific manner. Okay, now price for the goods may be fixed by the contract or may be agreed to be fixed later on a specific manner. Stipulations as to time of delivery are usually the essence of contract. Time of delivery are usually the essence of the contract if it is stipulated in the contract. Okay, now let us do an example. AB Limited enters. Okay, now AB Limited enters into contract with Indian Railways for supplying iron bars. Okay, for what iron bars will be supplied for construction of a bullet rail line. Okay, okay, but the delivery was supposed to be made on 31st of November 2020. But what AB Limited does, they make the delivery on 31st of December. Okay, now there is a delay of 1 month in making the delivery. Now, though time is not the essence of the contract, though normally this usually does not impact the contract, but because it's a bullet train project and the work is going on a full swing without any delay. Okay, and the labor force is there with all the resources. So if they are going to make a delay in delivery of iron bars, then in this case the contract can be avoided, and railways railways can refuse to accept delivery. But however, okay, now AB Limited is transacting is a cloth manufacturer and B is a cloth seller. So AB Limited agrees to supply cloth by 31st November. Okay, but they supply it on 31st December. Now in this case, because cloth manufacturer has a permanent shop and he is regularly selling the cloth, and if this particular cloth was not meant for some special purpose, if it was not meant for some special purpose and to be used in ordinary business manner, then in this case the delivery, though it is delayed but cannot be refused. Okay, now B cannot refuse the delivery, he has to take the delivery, because in such cases time is not the essence of the contract, though delivery is made at a later time. Delivery is made at a later time, but because time is not the essence of the contract here. Okay, because he is a regular cloth seller who's been selling clothes since so many years, and he has not ordered this particular cloth for some special purpose. Okay, he has ordered to be ordinarily sold it in ordinary course of business, and cloth is not a perishable product, and within a month cloth cannot go out of fashion as well. Okay, so considering all the factors, if there was no stipulation, then the delivery, though delayed, cannot be refused by B, because delivery here is not essence of the contract, it is not the essence. Similar is the case with the price. Okay, price may be made early, later, or in installment, okay, or in any fashion which may be agreed between the parties. But price not being paid on time will never determine the value of the contract, will never determine the contract itself. It will not affect the validity of the contract. Price may be paid at a later stage unless it is mentioned that price is the essence of the contract and it is to be used for some special purpose further.